Employment separation agreement. How to protect your company's goodwill when an employee leaves on dicey terms. Whether employees are terminated or voluntarily resign, they often leave their employer on rocky terms. More often than not, the business and the employee will agree that it is in their mutual best interest to enter into a separation agreement, rather than face the possibility of a lawsuit or some other future conflict. Find out how a business owner can use restrictive covenants to protect the company's goodwill when an employee leaves on dicey terms. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous. I'm here. I'm ready to have a conversation around employment separation agreements. Now, if you are doing as fantastic as I'm doing, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about how to protect your company's goodwill when an employee leaves on dicey terms. Now, protecting your company's goodwill, let's talk about that. The basic structure of a separation agreement is that the company agrees to give something of value, that's consideration, typically in the form of a separation payment, to the employee in exchange for the employee making certain commitments to protect the company's interest. One of the primary goals of any separation agreement should be to protect the company's goodwill. So your company's goodwill consists of those intangible, hard to quantify things that make your company unique, right? So on the balance sheet, which is a financial statement, those intangible assets are in the asset category. In other words, they are worth something. All of these things add value to your company, even though you can't touch them, but they're either difficult or impossible for another company to duplicate. Examples are your company's brand, employee relations, employee culture, reputation, supplier base, or customer list. In this video, I'm going to talk about how to protect these valuable assets when an employee departs. Note that company valuation often also include the company's confidential information and proprietary rights in the calculation of goodwill. In some cases, you even have trade secrets. Now, what is a non-compete clause? When it comes to protecting your company's goodwill, there are three clauses, three provisions, if you will, and those are called restrictive covenants. And I'm going to talk to you right now about the first one. The first one is a non-compete clause. Now, for folks, let me quickly give a disclaimer here. We're not a lawyer. We're not lawyers. This Sweetie Kiwi show is we do research. We reach out to lawyers. We just dig deep and we provide to you the result of our analysis. This is for your information. For your particular company, we would strongly recommend that you enlist the help of a lawyer, someone who is expert at your particular industry, who is adept at defending your goals, your objectives, your interests. If you don't have legal counsel in-house, all right, always reach out to an expert. Now, what is a non-compete clause? Oftentimes, a staff member will learn valuable confidential information about a company's business practices, customers, know-how, and strategies that could harm the company if that employee were to leave and work for a competing business. Think about it, right? Somebody has been working for you for the last 5 years. They have had access to a lot of stuff, a lot of very sensitive data, and now they're just leaving and working for the competitor. That's just crazy. That's just very, very harmful. That could be harmful for your business. So a non-competition clause, also called non-compete clause, is a standard provision in a separation agreement in which departing employees agree that they will not compete with a business for an agreed upon amount of time within a specific geographic area. And this includes working for a competitor or starting a company business of their own. Now, one effective way to structure the non-compete is to include a list with the names of specific company competitors. Those are called named competitors, for example. You want to also prohibit the employee from working or consulting with the named competitors. You want to define the business of the company as broadly as possible, because that's how you kind of cover your back here, your legal back. You want to further prohibit any activity that competes with the business, including but not limited to working with the named competitors, and prohibit any activity that competes with any future business of the company, whatever that may be. So, notwithstanding the natural tendency of a company to want the duration and geographic scope of the non-compete to be as onerous for the employee as possible, the law and courts have done this in the past 10 years. They recognize that it is in the public interest for people to be able to make a living. So, accordingly, each state has its own laws ensuring that non-competes cannot be too long in duration or too unreasonable in geographic scope. So usually it's usually 2 or 3 years, and it's within the radius, it's within a city within a city radius. It's very rare to have an entire state as geographic scope. So you want to be very specific, be very clear, and you want to name all the competitors that the employee is forbidden from working for. All right, I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of the Sweetie Kiwi Show. And as I told you before, we have 3 restrictive covenants, and I've already given you the non-compete covenant here. Let's move on to the second one. It's called non-solicitation provision or non-solicitation covenant. Before I move on to nitty-gritty of that provision, please consider subscribing to our channel if you love the clarity and quality of the show so far and you believe that we are adding value to you. You can turn on the notification bell, and we drop a lot of shows around business law every now and then. We cover a lot more though, but we do from time to time cover business law, so you will be very pleased with our future releases. So subscribe to this channel and share the knowledge, share the content with other similarly minded business owners, and also you might want to like the content and comment below and ask questions. Our team will review the questions and we could get back to you. Now, what is a non-solicitation provision? Now, often included with a non-compete, but sometimes overlooked, is a non-solicitation provision, sometimes called non-solicit. The non-solicit is often neglected because people frequently confuse the two or assume that the non-compete adequately addresses the issues covered by the non-solicit, but no, it's not. The truth is that the non-compete and the non-solicit work in conjunction, they work in tandem. So while the non-compete provides that the employee wouldn't work for a competing business, the non-solicit prevents the employee from poaching your company's customers, suppliers, employees, and other representatives. So the non-solicit is critical. It is a cornerstone in your arsenal, in your legal arsenal, when it comes to protecting your business from either sides of a competitive attack, right? So non-solicitation and non-compete. Now, what do you include in a non-disparagement provision? So a non-disparagement provision is the third restrictive covenant. So the first is non-compete, and then non-solicit, and now we're talking about non-disparagement. Employees may resign or be terminated for a number of reasons. So the mere existence of a separation agreement indicates that the employee may be disgruntled and leaving on bad terms. So because the separation agreement is premised on the contractual requirement that the employee receive consideration for signing the separation agreement, it is in the company's best interest to ensure that the employee cannot somehow damage the company's name and reputation while also receiving the separation payment. In other words, the company has paid, quote unquote, consideration, has paid money to the employee so that both parties can leave on good terms. But again, the fact that the company is signing a separation agreement in the first place means that things didn't go well. So the company that wants to avoid the fact that the company wants to avoid a double loss. So losing money on one side by paying the employee and having the employee not comply with the agreement, and the employee going there and damaging and hurting the company's name and reputation. So a non-disparagement agreement, a non-disparagement clause, to be precise, provides that the employee will not make any disparaging statements, whether orally or in writing, about the company, and will not take any other actions that could somehow damage the company's brand or any other products aspects of its goodwill. The non-disparagement provision should also contain a representation that the employee has not tarnished or bad-mouthed the company in any way prior to the date of the separation agreement. That's very important. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are still having a conversation today around employee separation agreements, how to protect your company's goodwill when an employee leaves on dicey terms. How do you ensure compliance with restrictive covenants? I've told you there are three. You have the non-compete, the non-solicit, and the non-disparagement. How do you ensure compliance with those covenants? Now, it is easier to control the employee's adherence to this restrictive covenants if the company has not yet delivered the entirety of the consideration to the employee. What I'm trying to say here is that if you don't pay the full amount to the employee, you can control his or her behavior. So what you want to do is you want to space out the payments. So you can space out the payments every month. For example, let's say you want to pay the employee, say, $120, $120,000. So you can space that out over 10 years, although the courts might bring it to 1 or 2 years or 3 years. So every month you could pay the employee, say, $3,000 over 10 years. I mean, over 4 years, that will be around 120 or 4,000, right? So if the company is delivering the separation payment to the employee in installments, then the employee will have incentive to strictly comply with the restrictive covenants until the employee has been paid in full. So, however, to protect itself from the inevitability of the employee having received the entirety of the separation consideration and no longer having any reason to comply with the agreement, the separation agreement must contain additional potential penalties for breach. So, common among those penalties are the company's right to immediately demand the return of the full separation consideration, including any profits derived thereof. The company can issue a temporary or permanent injunction. The company can sue the employee, and the company can have the employee reimburse the company for any attorney's fees incurred. So those are the potential penalties that you can include in a separation and an employee separation agreement to disincentivize the employees from pursuing an adverse course to your company's interest. So besides, the separation agreement should include a severability clause whereby the parties agree that if a court deems any of the restrictive covenants to be unenforceable, the court can modify the provisions as minimally as possible to make the clause comply with the law. All right, so this is it, folks, in a nutshell, what employee separation agreements are about and how you can protect your company's goodwill when an employee leaves on dicey terms. Now, to protect your company's goodwill, you got to either have a non-compete clause, a non-solicitation provision, or and there are three clauses. So non-compete, non-solicit, and non-disparagement clauses. And I also talked to you about how to ensure the compliance with those three restrictive covenants. Thank you so much for listening. I will see you next time. But until then, remember, stay marvelous.